Me today, though. I really appreciate it.
Of course.
Yeah.
My pleasure. Thanks for the invite.
Oh, no, happy to have you. Like I said, I'm a big fan of your blog. Uh, so it's a little bit like I have a celebrity on here.
Oh, yeah, we get that all the time.
So just a quick overview of how this all works is we'll record here. You can see us recording down there in your timeline. But once this is done, I'll edit it probably sometime next week, and then I'll send you guys a copy. You'll be able to listen to it, make sure it all sounds the way you want it to sound, make sure you don't misspeak or anything like that, or want anything cut. You go nuts and start talking trash about a bunch of clients. Don't worry, I'll cut that out. And if I miss it, you can tell me to cut it out later. So, point being, you'll be able to hear this before it ever goes live to our audience. And yeah, that's pretty much it. We want to make sure you're happy with the recording itself.
Excellent.
So the way it's going to work, I'll record my intro later once I kind of know exactly what we talk about. But to start, I'm just going to say, thank you for joining me on the podcast. Hi. You guys say hi back. Then we'll go into just kind of like a little, who you are and what you do for the industry. And yeah, then we'll go into the questions. Does that sound good?
Great. Yeah. I had one just as a heads up. So number 7,
Yep.
Where you asked about, just so the question is accurate, that we just did the webinar this morning.
Oh, great.
So instead of asking it, in the future tense, just that way, the answer jives with, but I think people can, I think the recording will be maybe available. So I'll reference the recording as opposed to people, being able to sign up.
Sounds good. And you have an event you're doing too later in the year?
In January, yes. So I can talk. We don't have a date yet, but that will be coming soon.
Yeah, we'll make sure to bring that up. All right. Sounds good.
Do you go by Steven or Steve?
Steven usually, just because I'm a junior, so my dad is Steve. Keeps things easier around the house.
Very good.
So, hi, Eric. Hi, Aaron. Thanks so much for joining me today.
Hey, thanks, Steven. Glad to be here.
Yeah, looking forward to the discussion. Thank you.
So, as we talked about this before we got on the call, I'm a big fan. But for anyone who might not know you, Eric, might not know you, Aaron, can you tell us a little bit more about yourself and what you do?
Well, that's great. I love that there's OSHA celebrities now. That's a good sign for our industry. But my name's Eric Kahn. I'm one of the founding partners at Kahn Maciel Carey, and I chair the firm's national OSHA Workplace Safety Practice Group. I've practiced for 24 years exclusively in the field of workplace safety and health. And for the first decade or so of that, I practiced alongside the first general counsel of the OSHA Review Commission. So that's a little on my background here.
And I am based in Chicago. This is Aaron Gelb. I lead the Midwest OSHA practice along with Eric. I'm one of the co-managing partners of the firm. Starting my 30th year in practice and being based in Illinois, which has some of the finest soil in the United States. I spend a lot of time working with grain handling companies, primarily in the Peoria area office, but other area offices as well, both Naperville and Fairview Heights, as well as significant cases across the Midwest, Missouri, Iowa, even some grain cases in Michigan, into Kansas, Nebraska, and beyond.
Yeah, and I know you from your fantastic blog, the OSHA Defense blog, or the OSHA Defense Report blog that you put out. And one of your big topics lately has been kind of the OSHA's heat illness prevention rule. What's going on with that? You've been writing a lot about it. I was hoping you could just give me a couple of the key elements for businesses, especially, grain handling, feed manufacturing businesses.
Sure. Yeah, this is it's interesting. We're coming down the final stretch of the Biden administration, and a heat illness prevention rule at OSHA was one of the agency's highest priorities, and they worked really hard on it. Actually, made a ton of progress on it during the last almost 4 full years, and we are at what I would call sort of close to the finish line for a rule, but what's going on with it and what's going to be going on with it in a couple of months are two different things.
Yeah.
This has been an incredibly active rulemaking. It was about 3.5 years ago or so. They initiated an advance notice of proposed rulemaking, basically put out a request for information about possible directions that OSHA might go for an indoor and outdoor heat illness prevention standard. Collected a bunch of information and data from that, put together some committees to work on it, organized a small business review process, and got to the point a couple of months ago where they put out a notice of proposed rulemaking, which is actual regulatory text, proposed regulatory text for a heat illness standard. We are right smack in the middle of a public comment period for that rule. Employers have until presently, they have until the week between Christmas and New Year's to submit comments to OSHA's rulemaking docket. We anticipate that that deadline will be extended a little bit, but probably not until past January 20th. So the public has its opportunity to comment on this proposed rule right now, probably until around the middle of January. The rule itself is a pretty remarkable rule. It is broad in its application. It applies to almost every employer in the country because it covers both indoor and outdoor workplaces and any workplace where there is a potential or foreseeable exposure to heat at 80 degrees heat index, indoors or outdoors. There are a few exceptions to it, but by and large, it applies to essentially everyone. And it's also extraordinary in some of the elements of the rule are particularly onerous. There are three that we there's a lot of elements to this rule that will be challenges for employers and that employers have concerns about. But there's three that we've flagged and that we've been talking with our clients and a coalition of employers and trade groups that we work with about. One is measuring and monitoring, in particular in indoor workplaces. And for many in the grain industry, we think of agriculture as an outdoor work activity, but a lot of folks in the grain industry have these hybrid indoor-outdoor workplaces, right? A grain elevator, a feed mill, where there's work that happens indoors and outdoors, and a lot of that indoor work is either in a non-climate controlled environment or in an environment where there is equipment and processes that generate its own heat. And so
Yeah.
you do have these potential high heat environments indoors that will be regulated by this standard if it's ever finalized. And for the measuring and monitoring piece, in particular for indoor work environments, employers are going to have to, if the rule is finalized as it's proposed, do a lot of their own measuring and monitoring. And they can and because the standard is not based on an ambient temperature trigger, you're having to calculate or measure a heat index, which means either getting special technology to measure for heat index or measuring for ambient temperature and humidity separately and calculating heat index, or obtaining a wet bulb globe temperature device, which is not readily available on the market right now, to do this measuring and monitoring, as OSHA says, in enough locations to be representative and frequently enough that you're keeping up with potential changes in heat index over the course of the day. So for a work environment like a grain elevator or a feed mill, you might have several to dozens of locations that you would need to separately measure and monitor for. And OSHA's expectation is that you would be doing it multiple times a day. So basically, turning employers into weathermen to calculate and log all of these heat index measures throughout the day. And that's going to be an administrative challenge and very burdensome if the rule is finalized in that way. The second of the three big concerns we've flagged is acclimatization. And we are, not opposed to acclimatizing employees to new high heat environments. I mean, the data jumps out at you in OSHA's preamble to the proposed rule the number of serious heat injuries and illnesses, or I guess the percentage of serious heat illnesses and injuries that occur in the very first week on a new job, tells you that this is a real thing and that it's something, it's acclimatization is important. But the way that OSHA has addressed this in its proposed rule is very rigid, very administratively challenging, and very onerous. There is basically a requirement to ease employees in working only 20% of their first day on a new job, where they may be exposed to heat at the initial heat trigger, that 80-degree heat index, for only 20% of the first day, 40% of their second day, 60% of the third day, and so on till a full week of easing into the workplace, where you're having to track who are my new employees, what day into the job are they, what percentage of the day is at the initial heat trigger, and what percentage of the day have they worked in a location where they're exposed to that initial heat trigger. So really challenging requirements built around acclimatization. And then they add to that by saying we need to do a similar reacclimatization for returning employees. Somebody who's been away for a couple of weeks at a time has to come back and be reacclimatized in a similar approach. And the final, particularly concerning element of this proposed rule is a very rigid requirement around cool down rest breaks. And again, no responsible employer is opposed to cool down rest breaks. But the issue with the way the rule is written right now is that you must do a 15-minute break every 2 hours with no flexibility around that. So you can't say this task is going to take 2.5 hours, so we're going to take a 30-minute cool down rest break after 2.5 hours. You have to do 15 minutes every 2 hours, and that doesn't count time getting to and from the break area, taking off any PPE, and any of that sort of stuff built in there. So if you've got somebody, for example, in a grain elevator who's up in the head house, and they're doing a task that's going to take 2 hours and 15 minutes, this rule would require them to come down before they're finished with that task, take a cool down rest break, then get all the way back up to the head house to finish the task. So you're climbing or taking one of these elevators or man lifts multiple times, without any flexibility built in there. And there's a lot of other elements. I could obviously talk about this for
Yeah.
days, but that's those are the big challenges we're seeing in that heat rule.
Yeah. Well, number one, sorry to make you come on here and talk about regulation that no one knows exactly what the Trump administration is going to do with any of it. So, uh, who knows? But also, like, I had hoped that there would be some kind of variation for where you live, because
Yeah,
here in Wisconsin, like, yeah, 80 degrees is pretty warm for us. It's only really hits that during the summer months in the later part of the day, but like you go down to the south, 80 degrees, I mean, 24 hours a day. It
yeah,
doesn't
yeah.
get
I
below
mean,
that in the summer.
that's Merry Christmas, right?
Yeah, exactly. So it seems, I don't know, really weird, to not have any kind of variation in that. Uh,
Yeah, I think OSHA was trying hard to, to not overcomplicate things, but it's a great point, and it's a great, uh, I think, miss in the way the rule is crafted right now. And we've been trying to come up with a bunch of different solutions for how that might be addressed. And one of those is look to, National Weather Service alerts and warnings and those types of messaging coming out of National Weather Service or some other credible weather service like that, because those are geared differently to different climates. They have different thresholds for when they will put out a high hazard, high heat alert in the Gulf of Mexico versus North Dakota. And so we've suggested either using different thresholds or using something like those alert services as being the triggers for some of the more onerous requirements of the standard. But right now, it is absolutely one size fits all. And it's one size fits all, not just for different regions of the country, but for indoor and outdoor workplaces. There are only the slightest variations in requirements based on indoor and outdoor work environments versus different industries versus work activities that might be extremely physically demanding versus just merely being present and sitting at a desk in a higher heat context. None of that is accounted for, and the science behind heat illness accounts for all of that. So I feel like that is a problem with the proposed rule that we're trying to work with the agency to recognize and address. But it's one of the challenges with trying to write a one size fits all rule of any kind is rarely does a safety measure, rarely does a hazard apply equally in every setting. But that's the kind of rulemaking that OSHA is often forced to
Mm.
try to tackle, and certainly what they're doing with this proposed rule.
Yeah, well, especially anyone who's 80 degrees inside a feed mill with machines running and the smell and everything. It's a really different experience than being outside with a slight breeze and working that way.
Yeah, for sure, for sure.
Um, so, besides the heat illness prevention rule, what other significant regulations or standards is OSHA working on right now, or planning to implement in the near future, or change in the near future?
Yeah, those are very different questions. What are they working on now, and what are they going to implement in the near future? Are different things, I think, because of the outcome of the election in earlier this month. OSHA has been working really hard on this heat illness rule. They've been working really hard on an emergency response standard to sort of modernize requirements around firefighting and other emergency response activities, which will have a serious impact in the grain industry as well, um, either because of the way it affects companies' internal emergency response programs or their reliance on volunteer departments in rural communities or professional fire departments in other communities. There is the standard as proposed is extremely onerous. It sounds like a broken record, but these are two particularly onerous rules that OSHA is proposing. So much so in this emergency response rule that there is a very broad and almost unanimous coalition of professional firefighting organization, fire chiefs associations, who have spoken up to say, look, we're all for modernizing firefighting protections and protecting our workers in this very hazardous work activity, but this standard goes way too far. And in fact, will cause, it will, goes well beyond the budgets of most community fire departments and would be impossible for volunteer fire departments. So that's a rule that is in a similar stage as the heat illness rule. A notice of proposed rulemaking was issued. The comment period for that one has expired already, and we are in the middle right now of a public hearing on that rulemaking. It's probably going to run for about a month. We've had a few days of the hearing already, so that's been going on. Another really big one is the worker walk around
Hmm.
representative designation process rule. That is a rule that OSHA is no longer working on because it was finalized and issued earlier this year. But that is a rule that makes it easier for third parties to get into private employers' workplaces as an employee representative during an OSHA inspection. And it was a controversial rulemaking. It steps on the toes of private property owners, private business owners, to exclude unwelcome non governmental third parties. And it was controversial because OSHA did not hide its intent with that rule, which was to make it easy for unions to access non union workplaces. That
Mm.
was really the stated intent of this rule. And that's, whatever you think about unions, and I'm not anti-union in any way, but whatever you think about unions, using an OSHA rule, a workplace safety agency rule to facilitate union access feels misplaced, right? There's
Yeah.
an entire agency, the National Labor Relations Board, whose job it is to facilitate union organizing. That really should not be the job of OSHA. So many people are concerned about that rule for that reason. What I'm most concerned about that rule is, even though that's what OSHA is intended, is that this is for unions to get into non-union workplaces. That's not the rule they wrote. The rule they wrote opens the door to any variety of unwelcome third parties.
Hmm.
plaintiffs' attorneys or their expert witnesses, disgruntled former employees that you've removed from the workplace, media, competitors, um, uh, you know, a variety of different individuals who might be able to now use this rule to wedge their way into your workplace and cause all kinds of problems and challenges for workers. That rule is presently in effect, and it's been there's been a legal challenge brought to that rule. It's in effect now, but that's another rule where maybe we'll talk in a little bit about what's likely to happen as we transition from a Biden administration to a Trump administration, where I think
Yeah.
all of these rules that we're talking about, heat, emergency response, worker walk around, even though it's been finalized, their fate is not sealed yet, and it may be on a different course in light of this election.
Well, yeah. I mean, and having OSHA visit your facility is already such a stressful experience, and then to have these third parties walking around too and
Sure,
having to worry about what they're seeing and what
for
they're going
sure.
to do at the end of this is it's a lot for any business owner to be expected to deal with.
That's exactly right. That's exactly, and you think about the likely third parties that would try to utilize
Mm-hmm.
this rule, right? They're not there to help the employer.
Uh,
They're there to
e-
make your life a little bit more difficult. So,
or even like you think activist groups who are going to come in and look at
sure.
a working feed mill and be like, oh, this is all gross and look at all these things going on, this is nasty, and then this is why you shouldn't eat animals and all those things. It's just a real slippery slope.
Yep, environmental groups, political groups. There's all kinds of different scenarios that we could imagine utilizing this new regulation.
And speaking of, having that OSHA visit, like I said, it's got to be so stressful for, especially in our industry where a lot of facilities are like still, there's big companies, but a lot of still local. They're co-ops or they're individual, feed mills or grain elevators. It's a lot to deal with, having a government agency come in and inspect you. What are some of the common mistakes companies make when they're interacting with OSHA, and how can these be avoided?
I mean, I'll jump on that one. I would say, and there are a lot. I've seen Eric and I and our colleagues have seen all manner of mistakes and missteps. I think first and foremost, I would say probably two things. One is failing to prepare for the inspection. The old adage, fail, failing to plan is planning to fail, and I think that truly applies here. From any number of steps that you can and should take, including figuring out, who's going to be part of the inspection team, making sure those people understand their roles and what they are to do and not to do, that they understand the rights and the responsibilities that they have, that the company has, but that also, what are OSHA's rights? What are the rights of your employees? I think far too often our clients, the ones that come to us, after the inspection is underway or even after the citations have been issued or contested, is they didn't understand, how to get ready, where to take the compliance officer, where to hold the opening conference, didn't understand what their rights were as far as limiting the scope of the inspection. Um, didn't understand about taking photographs, asking questions, taking notes, how to produce documents. There are a lot of things that if you know what your rights are up front and you're comfortable and confident in exercising them, inspection can go a lot better. Um, Second, I would say, is going it alone.
Mm,
It's one thing if they're coming out to, uh, someone tripped in the parking lot and suffered a fracture, and for whatever reason they come out to inspect that, or maybe it's a forklift inspection at a warehousing facility, and that's all they're there to look at, and they take a few pictures of the forklift and they leave. But that's pretty rare.
mm,
When you go it alone, and particularly if you're not prepared and you don't understand your rights, that can lead to a whole host of negative outcomes, right? You allow them to go where they're not entitled to go. You allow them to talk to people that particularly, I would say one of the biggest mistakes is allowing managers, superintendents, particularly senior leadership, to be interviewed by OSHA without being prepared, without somebody sitting in on that interview. I've seen cases that should have probably been 16, $30,000 citations turn out to be $300,000 citation packages because words are twisted, misinterpreted, put in somebody's mouth and work their way into a statement that then is signed, which should never have been signed in the first place. And then that is used to establish knowledge, and in some cases used to establish the basis for a willful citation. So particularly, again, we have clients that do it differently. Some that have us involved, via telephone for the opening conference and help them understand what happens when the walk around begins, but we're remote. There are others that will, particularly when there are serious incidents, we may be there before OSHA, right? So we're ready to participate live and in person the whole time. There are others that call us, while OSHA is waiting in a conference room, and we get our go bag and we hit the road to get there. Relatedly, I think a lot of people don't understand that you can ask OSHA to wait. They'll wait for at least an hour to an hour and a half. In some extenuating circumstances, you can ask them to come back or at least figure out a way to limit what they do before your consultant, your expert, or your attorney shows up. But it's going it alone and not understanding what your rights are that lead to a lot of negative outcomes.
Yeah, I would imagine as someone who's like sat in a lot of ocean prep conference talks and things like that at trade shows, you get this kind of false sense of like, I can handle this, right? I'll have my plan written down and it'll walk through and it'll be fine. But in reality, it's a lot it's a lot of money to put on the line, thinking that you have done enough research and you know what you're talking about.
Yeah,
Um,
I think on a related point, like we work on a lot of significant incident cases, right? Fatalities, engulfments, entrapments, and particularly in some cases where the employer may have a history, or in this industry, obviously it's a particular focus in parts of the country for OSHA. So they're kind of coming in at a heightened level of alert, right? The threat assessment level is orange, right? Just from the jump. And so if you don't know how to speak OSHA and listen and understand what's being said to you, I've had too many clients that come to me with really significant inspection pack or citation packages where I say, oh gosh, if only you and I had talked 6 months ago, either when the inspection started or even better, before this, there wasn't even an incident. So maybe we could have helped you avoid it, but at least, talking to us at the start of the inspection, and there are things that the compliance officers, either questions they're asking or statements that they're making, that some less sophisticated employers, and that's not I'm not saying they're unsophisticated people, right? Just not sophisticated or experienced dealing with OSHA, where we know that they're asking this question because they're really concerned about the lack of you fill in the blank, your bin entry program, your housekeeping program, whatever it is, and if you fix that during the inspection, you're not admitting wrongdoing. You're not admitting to a violation. You're showing them that you're serious and committed to safety. So we've had a number of really tragic cases where, working with our clients, they've hopped on immediately into fixing these things, and in some cases, we'll even share some of the things that we're doing in the middle of the inspection, so OSHA can relax and recognize, okay, this employer gets it, because I've seen employers that go it alone. They don't have our help. No one's interpreting things for them. And it's like, we don't understand why, we thought we were going to get a few serious citations and we got 5 willful violations and a $500,000 fine. And then you look at the inspection file and you see the compliance officer kept asking for respiratory fit testing records and training records and medical evaluations and HAZCOM training, and comments are made and misinterpreted. And then suddenly somewhere along the lines in that area office, they say, well, this company doesn't get it. we need to send a message. So here's a bunch of willful citations.
Yeah. Well, there's an art in the way to talk to them, right? And I love our industry. I do. They're some of the nicest people in the world, but we tend to be straightforward and honest. And that's not always the best way to go when you're talking to one of these inspectors. So I think I know gonna know your answer to this, but when do you think it is the best time to bring on some kind of legal representation when dealing with an OSHA inspection or OSHA citations or with just the organization overall?
So addressing the last point, you always have to be honest, right? And I'm not. I know
Oh
you're
yeah,
suggesting
don't lie to
otherwise,
OSHA.
right?
That's
Right.
clear. No one's given that advice.
I've had a few of those cases, and those don't go well. And when I find out that they think that somebody was dishonest before I got involved, I think again a lot of it is going to depend on what brings them there, right? Or so if there's an engulfment, someone loses their life, or multiple employees, fall into a bin, or a traumatic leg amputation. A lot of our clients are calling us before, like I said, before OSHA shows up, so we can even help them manage and direct that investigation. Some of that will then be covered by the attorney-client privilege. But certainly, my recommendation is to always call counsel while you're waiting to begin the opening conference, because I think Eric and I both believe that opening conference is absolutely essential to, because that's where you're going to talk about the scope of the inspection. That's where you're going to talk about how interviews are going to be handled, documents are going to be produced. And a lot of times, I think when compliance officers are talking to people, again, that really don't understand their rights and how to exercise them, a way to cooperate without giving away the farm, so to speak. That we can be, even if even if it's a client of mine in Kansas and I'm in Chicago, I can join that opening conference, and be effective remotely by phone, and maybe we delay the interviews until I can fly out there, or one of our people can be there. But so I think the time is either right after the incident, or certainly before you begin the inspection, before you say anything to OSHA in that opening conference that can and will be used against you. Certainly before you sit down for an interview, and I would say before you sign a statement, but my advice is to always not to sign a statement, period. But so just so people understand, hey, I'm not going to sign this. I'm not going to review this. I'll interview you. I'll sit down for this interview, but only after I've been prepped, or, met with my attorney. And for management interviews, right, we're sitting in on those interviews to make sure that everything goes, I would say, in a fair direction.
In addition to the those incident inspections, this is Eric now. I would say that there are circumstances where, either because of your history, your company's history with OSHA, or because of the purpose of the inspection, that even in the absence of an incident, the stakes may be high enough that it makes sense to get counsel involved. And I say that
Mhm.
because one of the trends we've been tracking for the last decade or so has been a pretty steady increase in the percentage of citations OSHA issues that are characterized as repeat violations. And repeat violations carry penalties that are 10 times higher than a serious or other than serious violation. And so if OSHA is out there to do an inspection, say under one of the grain emphasis programs, and you've got a few citations on your record involving bin entry, or work with an energized sweep auger, or housekeeping violations in the grain elevator. Those are prime topics, prime targets for a repeat violation in one of these programmed inspections. And if it's something that's in the sort of your core business area, and the stakes are high, it makes sense to at least contact counsel. It may not be that we're going to be, on a plane out to the facility. It may not be that we're on a call identified as being, present and representing you during the inspection, but we can advise in the background to avoid stepping in it, and to
Yeah.
avoid setting yourself up for these costly repeat violations, or getting dumped into the dreaded severe violator enforcement program, or being victim to OSHA's newest tool, the instance by instance citation. So if you're you've got something on your record, or they're inspecting you on something that is core to your business, lockout, tag out at in your machine shop, it probably makes sense to contact us. And one of the reasons why, Aaron and I are both at Con Maciel Carey instead of the giant 3,000 lawyer law firms that we left years ago, is that we wanted to be at a place where you didn't have to be worried so much to pick up the phone and call your lawyer because the rates are way too high. We've started our own boutique OSHA practice, so that we would be, we could right size our rates to take those calls, even in the absence of some terribly tragic event. uh, get us early before the small thing becomes a big thing.
Yeah, it seems like it's always at least worth having some kind of counsel on on file, ready to call, if they haven't already figured something like that out, because it can happen quick. Um, and speaking of your work at CMC, you guys produce one of the best OSHA blogs I read. I've already gushed over it. You also have online training courses, some other information right there on the site. Uh, could you highlight some of the most relevant courses for grain handling, feed manufacturing professionals? Uh, what should people be, educating themselves on?
Well, I'll tell you one thing that we've been doing a lot, really in the wake of that worker walk around rule, but also just as the Biden administration has been, an aggressive enforcement heavy administration at OSHA with lots of national and local and regional emphasis programs, getting sort of inspection numbers back to pre-pandemic levels, has been our OSHA inspection masterclass. And that is a program that we put together to help, your team, employer's team, boots on the ground folks that would have any role in an OSHA inspection, from the folks that might greet OSHA at the front door to the safety manager who would escort OSHA during the walk around inspection, to folks that might be involved in producing or organizing documents to produce to OSHA, or participating in OSHA interviews or organizing OSHA interviews, to really learn tips and strategies for every phase of the OSHA inspection, and to get access to a bunch of tools that we've developed to help employers successfully manage OSHA inspections. So that's a good one for the grain industry, really a good one for any employer. And another is our record keeping masterclass, to help employers master OSHA injury and illness record keeping and reporting. When you have to, put injuries or illnesses on your 300 log, create your 300A annual summary, pick up the phone to call OSHA after certain types of incidents. Those are low hanging fruit, easy mistakes that employers make, extremely high frequency citations. And you can get it wrong both ways, right? I mean, everybody thinks about, well, did I get it wrong and leave something off my log that shouldn't have been there? Well, these days, it may be just as problematic to put something on your log that didn't need to be there, because that data is now being handed over to OSHA proactively under the electronic record keeping rule. And OSHA is using that data, whether from e-record keeping, the BLS annual injury survey, or just collecting that data during inspections, to develop emphasis programs to target individual employers, and to use that data against you in a lot of different ways. So getting record keeping right has never been more important. And so we've got those two programs we put together that we're getting rave reviews about them, and we really enjoy spending that kind of time with employers, educating and really just talking through even scenarios that they've experienced during OSHA inspections or challenging record keeping situations. So those are two programs that I'm very fond of, that I'm involved in both of those trainings personally, and would encourage any employer, especially employers in the grain industry, to reach out and get signed up for those.
Yeah, definitely do. Especially since I'm guessing like stuff like record keeping is, I mean, it's a lot to do, especially when you're running a business full time. So easy thing to mess up. Aaron, you led a webinar today
Yeah,
as we record, but should be available by the time that this goes out, hopefully, for the Missouri Agribusiness Association. You also have an event coming up in January. All things that our listeners might want to go to learn a little bit more about OSHA and OSHA regulations and OSHA compliance. Can you give us a little more information about those?
sure. Yeah, it's been a busy year speaking about to the grain industry. I think it started in February at the Grain and Feed Association of Illinois' annual meeting. Did a presentation focused on bin entry. Today's webinar, as you mentioned, with Missouri Agribusiness, was focused on a new regional emphasis program out of the Kansas City region, which goes online in Missouri. It's gone into effect. Enforcement will not be. There's a 90-day outreach period, so enforcement begins January 1st in Missouri. There previously had been local emphasis programs in Kansas and Nebraska, but Missouri, for whatever reason, did not have any grain focused emphasis program. Illinois does as well, so they were kind of sandwiched in there and kind of skating by, so to speak. So OSHA rescinded the Kansas and Nebraska LEPs and have replaced it now with a Kansas City regional emphasis program that focuses on that includes Missouri and those other two states. And what that means essentially is that employers now in those three states, along with all the other states that are already subject to grain handling emphasis programs, that employers in those industries can and will be inspected randomly. So based off a list that's randomly generated at each area office based on an organization's NAICS code. So your industry classification gets you on this list for random inspections. And we always like to point out that that means you could have a year without an injury on your log, without anything reported to OSHA, without any complaints, but your number literally comes up on this random list. And then they come out to do an inspection, the scope of which is determined by the emphasis program directive. And in this case, that includes housekeeping, preventive maintenance, and bin entry programs, along with a number of other issues, whether it's falls, electrical safety, confined spaces, that they're going to be looking for machine guarding when they're doing the walk around portion of the inspection. And in addition, if they come out for another reason, because this emphasis program applies to folks in the industry, they can expand into these areas from that inspection opened for another reason. And it's important to understand that OSHA creates emphasis programs based off of data and experience. So they believe that there are unique and persistent hazards in this industry. Hence, they create this program to get into these workplaces proactively to try to find and address these things. So I think consistent with what Eric's talking about preparing is ideally we love to work with companies in this space and a number of other spaces, but because we know the issues and because we have a network of consultants who are, we have vetted and tested and approved based on our experiences with them, who are grain safety experts. We often are engaged to come in, do assessments of operations before anything happened, right? Improve the programs, improve the training, help roll out an auditing program. So that way, if OSHA does show up, the likelihood of an outcome is far better. And I think kind of as an addendum to what I was saying before, another mistake that folks often make is hiring counsel who is not experienced OSHA counsel. It'd be like going to your general practitioner doctor for a specialty. If you have a kidney issue or a cardiac issue or liver, and you just go to your general doctor, like, yeah, they know medicine. Other lawyers know the law, but if they haven't handled an engulfment, if they are not a known commodity at the area office, where the area office trusts them to be straight shooters, they're not used to being on site. It's going to go a lot differently than dealing with counsel that knows what they're doing. And so I think that's kind of it's failing to retain counsel, but it's also failing to retain the right counsel at the right time.
Yeah, you wouldn't go to you with for your divorce reason or lawyer
No, yeah,
purposes,
I
would
would
you?
definitely not want to work on that either.
Well, thank you guys for joining me today. If people want to know more information or reach out to you, how can they do that?
Well, we're easy to find. Check out conmaciel.com is our website. Check out the OSHA practice page there. You can find Aaron and me. All of our contact is available there. Or you could, shoot me an email directly, econ@conmaciel.com. But like I said, I'm easy to find, and I'm OSHA guy on Twitter. I'm all over the place. So, like you said, that OSHA celebrity status now. You can find us that way.
Awesome. And everything that we mentioned, including hopefully the webinar Aaron had recorded earlier today, will be linked in the show description, so you'll be able to find it right down there. Well, thank you guys. I really appreciate you coming on and talking, especially about regulations that might completely change in a few months here. We'll have to have you on again once Trump takes office, and we can have a little bit of a better understanding about exactly what might be coming down the pipe with his administration.
Sounds good.
Wonderful. Thanks, Stephen.
Thank you. And thank everyone out there for listening. Till next time. Bye. And that's it. We're